Hi, my name is Krishnan. Welcome once again to my presentation episode number 10 on inheritance law. In my previous presentation, I covered will, legal heir, succession certificate, nomination, etc. Today we will go through gift, its basic, and then let us compare all the instruments. Since the last three chart will be a comparison, it will be easy to understand. I will elaborate from the chart direct. There are three slides containing the charts. I have tried to give comparison of all major instruments of inheritance law like will, succession certificate, gift, legal heir, relinquish deed. Let us look at the charts now. Before that, let us look at the topics. So these are the topics for the day. Let us go to gifting. Gift. As you all know, gift is giving away something. It is given out of natural love and affection to someone close or within the kin. Sometimes there are some obligations, sometimes it is given for safety also. Mostly it is given within relations, but sometimes it is also given to outsiders. This is akin to donating. When you are gifting to kin out of natural love and affection and there is no pressure or coercion, then you have to give a registration charge of 1%. That is basically the metro cess in Maharashtra. But if you are giving to anyone outsider, then this tantamount to a transferring and the applicable stamp duty will be required to be paid as if it is a property sale. It is akin to a property sale when you are selling it giving to somebody. Though there is no purchase sale transaction happening, it is just a gifting. No money transfer also happens. Still it will be treated as a property sale and stamp duty will be applicable. In other places also gifting, there are ways of gifting and there are little charges in other states. One must remember that donee has to add the value of the asset received, whether it is property, anything else, he has to add the value of the asset received in his annual income and show. But that is not applicable if it is a transfer to a kin. Clear? So normally what happens, generally within up to 50,000 you can gift. Anything beyond this is taxable in the hands of the donee. But for relatives, direct lineal ascendants, your spouse, brother or sister, spouses of your brothers or sister, maternal and paternal uncles and aunts, lineal descendants and ascendants of your spouses, if these people gift you, then there is no tax, and vice versa. In Maharashtra, earlier the stamp paper used to be 200, now they are charging 1% as the registration charge, introduced from 1st of April 2022, that is a month back before this presentation is made. So maybe if you have one and a half months back, if you had done it, probably you could have done it with the 200 rupees stamp paper, but now you have to pay 1% of the value, the ready reckoning value of immovable property or the value of the material what you are transferring. Gifting immovable property is like transferring of property. It can be either given to a kin or outsiders. As I mentioned, there is no tax or stamp duty if it is kin, but if it is outside, it is like stamp duty applicable. The only 1% metro cess which is charged, that is different as registration charge, is different. You need to make a gift deed, you need to value it, okay, and it varies from state to state. You need to have 2 witnesses, and it is mandatory to register the gift deed with the register of assurance. Let's go to the next sheet. Okay, donee must accept during his lifetime and during the lifetime of the donor. So both must be alive for gift to happen. It is attracted by the Transfer of Property Act. Minors cannot be cannot transfer because they are not eligible. They do not know what this means. It's not allowed. If you want to give something to somebody with immediate benefit, gift is the right answer. But if you want to give it on a long-term basis, will is the answer. Gift is given during the lifetime, will is given after the lifetime. Only in both cases, only own property can be gifted, not ancestral. With this, we have discussed all the major inheritance law, be it will, gift, succession law, succession certificate, legal heir certificate, legal heir, and succession certificates act as an alternative to many assets, but not all, and not movable property, definitely not. In case of succession certificate, you need to have a letter of administration for taking over the movable property and act upon it. In case of legal heir certificate, since it is easier to obtain, some of the benefits investment can be immediately acted upon. There is financial transactions you can do. This certificate, then you can use it to obtain succession certificate, which then becomes faster. So it is best to apply for legal heir first and then succession certificate immediately, so you get both quickly. With that, with succession certificate you can start operating all the accounts, transact, do, buy, sell, give check, take check, receive, whatever. Okay, because legal heir doesn't allow you to inherit, so you can't even operate or not transact. Whereas succession certificate allows you to inherit, not own. And since you can inherit, you can act, transfer, buy, sell, pay, whatever you want to do. But with succession certificate and a letter of authority, it is equivalent to will. If there is no will, you should get succession certificate and start controlling operations. And this is also generally available, as I mentioned, over a couple of months. But this does not give ownership. So in the absence of will, you should apply for a letter of administration in favor of a single legal heir, which others should give release. Now, what I am saying others should give release, that if there are many legal heirs, they should nominate one person, and that one person will be in charge, and all other gives a release deed to him. They give release their shares in favor of him officially. But also the case of Gautam Singhania and Vijaypad Singhania, because Vijaypad gifted everything to his son, the entire JK empire. His son threw him out on the roads, right? And then he had to suffer a lot, but whatever internal issues, we don't know, but it was already something which was given and closed. And and there are many cases like that happening within brothers and sisters. So it is best to have a family agreement done, register that, get the family agreement, incorporate the sections letter of administration, and also then we will give the release deed. So once he get the letter of administration stamped, signed along with the succession certificate, he can operate to get control of all those things and own it up, and then he is bound to give the shares to others in their proportion of what they have agreed. Let us also understand there is a fine distinction between gift deed and release deed. There is a marginal difference between gift and release deed. The Delhi High Court, in the case of Tripta Kaushik versus Sub Registrar Delhi and another, carved out a test to determine whether an instrument is a gift deed or release deed. Okay, if it is released to all co-owners, then it can be treated as release deed. But if it is only given to a single person, then it is a gift deed, and therefore if it is not a relative, obviously all the duties and stamp duties and all other things will come in, right? So that is how it is. Comparison. Okay, now we are coming to the last three slides, which is entirely comparison, and there are 5 columns are made out: will, gift, release deed or relinquishment, which is basically I am releasing it to somebody, succession, legal heir. The first thing is who makes it? The owner makes it in all cases. Is it a written document? Yes, it is a written document in all cases. Who can stake claim? So in case of will, all the legal owners can stake claim. They can stake claim on all assets. Whereas in case of gift and release deed, it is only specific to the property in which the gift or release deed is given. Succession certificate again follows, in most cases succession certificate and succession and will, they follow the same, assuming that succession is having a letter of administration. If it doesn't, then it's one step lower to will. So this succession certificate in this case facilitates collection of debt securities, afford protection to parties to debts, no power on estates. Power of estates will come when there is a letter of administration. Legally it doesn't arise at all, because it only gives a relationship, nothing beyond. It only says so and so is related to so and so. This means nothing excepting that the relation is there, that's it. Who benefits out of this will? Everybody. Who was the relation? Gift, the person who receives it. Similarly, the release deed, and in case of succession certificate, again all the family members, debtors and creditors. In case of legal heir, it is not applicable, no one is there. Functions is to empower, to take over assets and operate everything. Gift is only to make a gift, and release is only to, for certain purpose they give a release deed to meet that purpose. Succession certificate is similar to will but without ownership. For ownership it requires letter of administration while transferring. Legal heir, it's not relevant again. Allows holder to act and benefit as given will. So he has open, in case of will the action is indefinite, I mean complete. He can do anything with anything, whereas in case of gift the donee gets to act on specific asset gifted. Release deed, again same thing. Succession certificate allows holder to take charge of all debts and securities but not own. But if it is with letter of admin, it is same as will. Legal heir, nothing is there. There is nothing to say on the legal heir. In case of will, who decides? Owner decides. That testator decides. In case of gift, also the owner decides what to give, how much to give, and even in will it is what to give, how much to give. In case of release deed also same. Successor can only administer, so there is nothing to decide. But once he gets a letter of admin, then all the owners decide who should get what as a family agreement. Legal heir, of course, it doesn't matter. Validity of will is after the death of the testator. Validity of gift is during the lifetime of the donor. Validity of release is again during the validity of the donor, and in this case succession it is only can apply only after death, and again the validity starts from there. And in case of legal heir, if you are asking for validity, it is only it can be validated only after a death. Okay. Next question is who gives a validity? The validity is given by the court in case of will. In case of gift and release deed, it is given by the sub-registrar both. In case of succession, again follows the court because court gives it. In case of legal heir, the tehsildar, the local tehsildar gives it. Payment, there is no payment to be received given. Again gift is free. Release deed, sometimes receiver may or may not get payment, may not make payment. Receiver, the giver can take, sometimes may not take. Succession, this does not apply, and once the letter of admin is received, then again it is without any payment, everything is distributed, assuming that there is a family agreement. Legal heir, nothing to not applicable. Registration, of course there is a need, I will call it going to the court itself is a registration. Gift, you need to compulsory register with the registrar of assurance. Release deed, again you need to be compulsory registered in the court. You are giving an amendment, but before that you are making a family agreement which needs to be registered with the registrar of assurance. Succession certificate, again since you are going to the court, I will say it is compulsory to register, otherwise you can't progress further on that. Legal heir also I will say it is equivalent to registering because you are giving all document, making up something, you are giving it to the government, and tehsildar office gives it to you. Will, it is governed by the Indian Succession Act. Gift is governed by the Transfer of Property Act. Release deed is by the Registration Act. Succession is governed by the laws of succession, and legal here is also governed by the laws of succession. Will, it can be revoked during lifetime. Gift once given cannot be revoked. Release deed once given cannot be revoked. Succession once given to a person cannot be revoked. Legal heir certificate can be revoked if there is a fraud that is found out. Will, probate is the item thing that authorizes a named person for executing. Gift doesn't arise. Relinquishment doesn't arise. Successor is named here in the letter of administration to also, so that there is a document. In case of legal heirs, all named all the names are there in the certificate. Okay. Application bill is applicable to all the 4 cities plus Assam, Bihar, Orissa. Gift applies to all over the country. Release also, succession also, and legal heir. All these 4 other applies all over the country. Okay. In will there is no tax. Gift, no tax if it is only to close relatives gifted. Release deed, no tax if given to close relatives, L taxable. Succession tax again follows the will, and legal heir, such a thing is not applicable. Okay friends, that's it about the inheritance law and the various instruments you have for acting under different circumstances. Like any other good thing, this also comes to an end. The inheritance law comes to an end. I hope all of you have benefited with this presentation. I will try to add more on RERAs and then cooperative housing society also if possible. Okay, so now let me get back to the stretch. So friends, do keep watching, and I have already mostly prepared the RERA presentations, so that will be out soon. Till our next meeting, this is Krishnan signing off and thanking all of you for watching the video. If you have liked it and or gained knowledge, please press the subscribe button and also leave your comments. Your subscription will help me encourage to do more such presentations. Okay, so will your comments be. And I also would urge that circulate this to all people, because let people be aware what is what. This is something which I find very few people are aware and not willing to get into it. They think things will happen. Let them understand there is some rules and laws that has come in place. Let people understand this so they can take steps accordingly. It should reach all across the length and breadth of the country. So people should be aware whether it is in big town or it is small town. So please do circulate. Let it gain popularity. Let people learn and understand. Thank you all so much for watching the video. Thank you so much once again.